everyone, this is Mallory Flowers on behalf of Jennifer Shelton Associates, and we are coming to you live from Washington, D.C., and welcome to our webinar Wednesday series. Our webinars are held every Wednesday in 2018 at 12 p.m. and 12:30 p.m. Eastern Time, and our speakers range from accountants to attorneys and other industry professionals. The full schedule for the rest of the year is on our website underneath the webinar tab. In the interest of time, we do not take questions, and our speakers' contact info is listed on the last slide. So if you have any questions, please contact the speaker directly. The recordings are on our website underneath the archive webinar tab, as well as on our YouTube channel. All right, this is just a quick blurb about us. Jennifer Shelton Associates is based in downtown Washington, D.C., and we help both product and service companies with federal contracting. Our clients are domestic and foreign, defense contractors and civilian, and our services range from market analysis reports to contract vehicles, including the GSA schedule. We can also help you with proposal writing and post-award contract administration. More information about our services and upcoming events can be found on our website. And this is one of our upcoming events coming up on November 27th that you can learn more about on our website. All right, so we're going to go ahead and dig into today's presentation, which is Contract Strategy, Claim or Request for Equitable Adjustment. And our speaker is David Dempsey. And this is more about his company that you can go back and look at. And I'm going to go ahead and hand over to you, David.
Okay, thank you, Mallory. I think first thing we ought to do for the attendees, who I appreciate listening in today, is go to page 7. And from there, you'll notice that I've got this as a contract strategy, because sometimes you want to file a request for an equitable adjustment. And sometimes you're already so fed up with the government that you just assume file a claim. The approach I'm taking is to try to describe the thought process that you may go through to get to that decision. Okay, so on the next page, I'll just give you the basic statutory and regulatory background, because this all is based on whether you're going to file a claim or not. And the Contract Disputes Act covers supply, services, et cetera. It does not include the non-appropriated fund instrumentalities, such as AFEs. Excludes the FAA because they have their own statutory background. There's now 4 boards of contract appeals, because the Civilian Board of Contract Appeals, or the CBA, consolidated what seems like about a dozen. I've been before all these except the TVA, and don't know if I'll ever get a TVA contract to go through their board on. Court of Federal Claims, under a different statutory authority, will hear Court of Claims. They won't, declare the dispute. And then the DFARS sites there give you an idea of what to do for purposes of getting the paperwork, so to speak, out of the way. Other agency FAR supplements usually just talk about the given agency's alternate disputes resolution program, but once in a while they'll have something different. But the practical matter, you want to check it all the time before you do any claim or REA process. Now on the next page, which is page 9, we've got the definition of a claim, and I'm pointing out that claim also includes interpretation of a contract term. Most people think it always has to be for money and a sum certain, as it explains there, but that's a CDA requirement, Contract Disputes Act requirement. And then a claim has to be sent to for a final decision to the contracting officer, and as a practical matter, you ask for a final decision. And then on the next page, under those procedural issues, the first thing I bring up is the statute of limitation for a contract claim. And it's 6 years, and it becomes relevant if you decide to do a request for an equitable adjustment process, because that REA process can take a year or two. And while that's going on, you are having the statute of limitations tick away for purposes of filing a claim. And then we have some other relatively straightforward requirements for a claim. the dollar threshold, and then the certification, which, as you can see, comes right out of the FAR. And as you see in a couple of more slides, there is a recommended, if not required, certification for the Defense Department, but I would recommend you use that same certification for any REA that you submit. And then I've got down at the bottom there that the claim has to be signed by an authorized official of the contractor. And I bring that up because there's a recent decision out of the Armed Services Board where the board said it wasn't signed. It was just an S/ and a name, and we require a actual signed document. So if these procedural issues get in the way, essentially it's a defect, and you start all over again. Claim, not an REA, but for a claim. And of course, that's when while you're doing that, the 6 years is ticking away. So with respect to what causes a claim, what precipitates the REA, I should show that on the next page. And I start with the government. Now, the government will frequently have a design or performance spec that leads to multiple interpretations that are not discussed, et cetera. And a contractor either bid things one way, put their cost proposal or put their staffing proposal together in a certain way that their interpretation of it. And it's the government's fault. Somebody concludes that it's the government's fault, because initial reaction is rarely that it's the government's fault. And then there's the rush procurement process, which is the only diplomatic way I could say is that there seems to be a lot of inexperienced procurement personnel on the government now. So things may have taken a long time, but things get rushed, or the process gets rushed as they get closer and closer to announcing or issuing the actual solicitation that they want offers on. And then there's, as with any look back on why something happened, someone's always going to say there were poor communication. But in this case, I think it's the government's Q&As. Sometimes they can be oblique, indecipherable, etc., and they won't be questioned on it. If there's discussions, and there's some sort of discussions are sent to the offeror with a question that does not seem particularly well worded, the offeror will not immediately come back and say, what did you mean by this? And the reason they don't do that is because frequently along with the discussion question is a deadline that says we want an answer to this and the other questions, however many there may be, for submission, and the contractor, instead of asking for an extension or raising questions, tries to answer things. And of course, nowadays we have a lot of no discussions. And then one of the more subtle areas where claims and REAs tend to generate from is the agency's mission requirement versus the contract requirement, and that's obviously related to the rush procurement process. But this will show up a lot in the military agencies and and to some extent the intelligence community agencies, where they don't quite want to say what their mission is for whatever reason, even though they're only dealing with cleared contractors, and they put in their contract requirements something in the statement of work that can get oblique. Now, on the contractor side, which I have on the next page, to a large extent, this is a repeat of the government's, and it's but it's the contractor's fault this time. Like I've said, the misunderstanding of Q&As and the discussions just went over. The contractor won't get into it. And then there's an insistence sometimes, because I've had this experience with companies, where they don't really care about what the agency mission is or the purpose of the contract. They just go by what they think the contract says. which of course leads to the next little bullet there, is that they didn't read the contract, or they didn't understand the contract because the work statement was obscure, or they, missed the fact that the Service Contract Act wage determination was not attached, although it was referenced, little things like that. And then during contract performance, I've got failure to properly schedule work, and that should probably read failure to properly administer / schedule work. And that is a function of subcontractors or the company's contract administrator, subcontract administrator, not paying as much attention as he or she should to the requirements that the sub is supposed to take care of. And because the prime is the one with responsibility, the prime contractor ends up with a claim where they want to request more money because of something their subcontractor do. And then on resolving these initial issues, this is again listed on page 13. I've got better communication because I felt obligated to state the obvious a couple of times during this talk. You can say better communication for just about anything. But on better understanding by the USG, there's a little subtlety there, because first thing you have to understand, or first thing a contractor has to know is there going to be a lot of government turnover in contract administration personnel associated with what you're doing. If it's a task order, probably not. If it's a 3 to 5 year option contract, it's a good chance there's going to be a new administrative contracting officer, or ACO, or a new CO or PCO, and then more importantly, is there going to be a new COTR, or contracting officer's technical rep, working on your contract. And then, just as a quick aside, everything I'm saying more or less applies to a company's role as a subcontractor to a prime, and if it's a major prime, Lockheed, SAIC, that sort of thing, then you gotta hope that you got the same concerns there about turnover, experience, that sort of thing. One thing that you always notice when you're looking back after a REA has been negotiated or claims been filed is the parties didn't really understand their contracts. And that's almost always in the attachment, Section J attachment, or in Section C of the contract, and very rarely does it seem to be anywhere else. And then last preliminary observation that I've got, and this I'm on page 13, is that, which is, I think it's the next page, Mallory. The last one is the resolving claims earlier and at lower levels. Now, lower level can mean the ACO, COTR if they have authority, and then of course the PCO before you get into the management of the procurement office that you're dealing with. And some government officials don't like to recognize that something has gone wrong with their contract, and they blame the contractor. Same token is contractors don't like to think something went wrong, and they blame the government because that's all they're getting from their own representatives. And then there's a we'll resolve it later type of thing, or a we'll sort it out approach, which usually just festers. And if you don't have good record keeping, you can end up having incurring costs. Contractor can end up incurring costs and not quite realizing it. until they start looking at their budgets and their other accounting data, which indicates where they met a budget or not. So now I'm in on the next page, which is page 14. I'm into the request for the equitable adjustment or the REA itself. First of all, there's no format. It's just a letter, which is a practical matter. It's the same thing as a claim. And there's no definition. So we go to the FAR policy in 33.204, and it says it's the policy to resolve things by mutual agreement, and reasonable effort should be made to resolve controversies. And that's pretty much the request for an equitable adjustment. Now, an REA, of course, is going to presume money damages. It's not going to presume, some contract interpretation issue, because that's a letter in a meeting rather than a formal submission. And a breach of contract is not where you would start with an REA, assuming that you believe it was a breach before any process started. And then an REA does not cover the T4C settlement proposal. That's just something to work out, but it's not. It's going to be around a contract change is what REAs generally focus on. And in a few minutes, I'm going to have a slide where basically you can have a constructive termination for convenience, but that's going to be different than the T4C proposal itself. And then now you're at the position where you want to file a claim or you want to file an REA. Before you do that, and before you even get into discussion, you better check your contracts, make sure what changes clause you have. And these are the basic ones. And we note in the commercial items clause that it's going to be hard to base an REA or a claim on a bilateral contract mod that you've already agreed to. You essentially are going to be stopped from doing that as a function of common sense, unless what you agreed to is of course not what happened as the mod progressed. So beginning on page 16 now, we've got what the REA is, and that's going to be a government delay, a stop work order, and there's a government delay clause, and there's a stop work order clause, and there's a suspend work order clause. And those clauses particularly say if this causes you damages, then the clause says submit a request for an equitable adjustment in price or schedule, and we'll sort it out. But that's going to be a formal process under that clause, and it's not quite what I'm talking about here. In this instance, for an REA, I'm essentially talking about the constructive change. So on the next page, we've got the reference to a constructive change. Constructive changes have been, as it indicates there in the third bullet, is developed from case law and a recent decision out of the claims court. It reads like this. They said a constructive change occurs when a contractor performs work beyond the contract requirements without a formal order under the changes clause, either due to an informal order from or through the fault of the government. And this is what I mean by action or inaction of the contracting officer. And that was cited from a CBA case, or CBCA, which is the Contract Board of Appeals for the civilian agencies. And then they also cite the same reference cites some Court of Federal Claims decisions. So that's basically what we're talking about. Now, the two bullets here that I want to emphasize is the authorized government official, because that will always be the government's first defense when a constructive claim comes in. And we focus entirely on the COTR, usually, who has a delegation of authority, which will say a lot of things. And one of those things that we'll say is that the COTR is not authorized to make changes to the contract, or a contractor is not is put on warning that they better not take the COTR's word for a constructive change. And then on the contractor side, we've got the contractor not volunteering. And in a lot of seminars like this or webinars like this, I'm always making fun of the engineers and the salesmen of a company. And since we're in contract performance, we got the engineers, the contract administrators, and anybody else who has contact with the government and is a nice guy and is willing to help the government or foster relations between the government and the contractor so everything goes smooth. That's fine until it starts to cost time or money or both. I've also been asked in the constructive change area what the difference is between a cardinal change and a constructive change. And cardinal change is something way outside the scope of the contract, which would be, say, increasing the scope of work, estimated hours, et cetera, by say 400%. That'd be cardinal change, versus the government saying we want to up the hours on this particular line item, and it's say 100 hours out of 100,000, or say 10,000 out of 100,000, and there's no real authority given that anyone can trace, and that's why we get back to the authorized official argument or fact that's got to be sorted out. And this is important for companies' contract administrators to know who's got the authority to order a change, and it's up to that contract administrator to make sure that company people don't go around being nice, as I've said, or not paying attention to the record keeping. If a change is made, and it's a small change, and this could be a one-off, or it could be from that point forward, and everybody's got to talk to each other on the contractor side. The go no-go decision on an REA versus a claim, some people perceive an REA as less confrontational and may facilitate a timely resolution. I don't have any experience one way or the other. I've got a lot of experience with REAs and claims, but I can tell you they're not definitely less confrontational if you've had your third meeting on something. The biggest question about REAs is whether you can recover your prep costs. I'll be getting to that. That's in the last two slides. And then the reasons against filing an REA versus just submitting a claim right away is you can't recover interest. That's correct. Interest rate is 3.5% right now from June to December 2018, and that's the highest it's been, since June 2012. So that's interest rates going up. And then there's no time requirements to issue a decision or make a resolution on REA. And when you keep in mind the 6-year statute of limitations, that can get relevant. And then you don't have any discovery. When you file a claim, you're going to go through a discovery process and get government information. Whereas in the REA, all you're going to get is statements and other representations from the government. And it's my impression that they do hide stuff. So I know what I do is when we file an REA, somewhere in there, I also have a hold notice so that the government doesn't go around destroying documents and emails and that sort of thing. Not that the government ever do that, of course. And then the judgment fund is another bullet here. One of the reasons a contract officer, they want to avoid an REA is because they don't have any money. But if you file a claim, he denies it or she denies it, and you go docket it, now the agency is eligible to use judgment funds, and they can pay the claim from that. And then the law says the judgment funds have to be paid back within a year, and I've never seen that happen, but I'm sure it has before. It's usually 3 or 4 years, and let's say 2 or 3 years, and by that time, the contractor and the claim are gone. Okay, and then another reason against an REA is if it doesn't work out, you start over. So the reasons for the REA are on the next page. This is 19, and we pretty much gone over those, but they're also pretty straightforward and they're self-explanatory. So now when you submit an REA, and this is on page 20, it's essentially like a claim, and you got to give details because it's a serious document, as I'll be saying on the next page, and you've got to have a pretty good idea of what your damages are. You have to have a very good idea, and you have to have a legal theory behind it. Now, below there is the DFARS certification I mentioned at the outset, which says I certify that the request is made, and now it's a non-DOD agency, it's there to certify that this request for equitable adjustment is made in good faith, etc. But notice that's a statement, so that's going to have, the usual false statement problems behind it. And now, DFARS reference refers to REAs exceeding the simplified acquisition threshold, which is now $250,000 rather than $100,000. Okay, then when we go to the next page, now we're getting into the things that I'd like you to keep in mind, which is it's a serious document. It's not an opener, and you shouldn't look at it that way. Make sure that you're not doing it just to cause any people on the government side issues, contract administration issues or embarrassment or anything like that. Be as accurate as you can. I've got no reckless factual assertions, and by that I mean, no double hearsay statements about who said what, and then so-and-so heard about it, 3 or 4 weeks later. And in other words, everything's got to be substantiated. And under legal positions, calculation of damages, you have to be sure to determine if there's been any mitigation on your part, mitigation of damages, which you're going to be required to do under any circumstances. Now, one of the benefits is recovery of REA preparation costs. And here, in the 2001 decision, the Armed Services Board of Contract Appeals says, if something comes up, if an issue comes up, there's going to be contract administration costs, which should be allowable since the negotiation process is supposed to benefit the government and avoid the claim. And for purposes of putting together the REA prep cost analysis, I've given you the FAR cost principle 31.205-33 on legal, accounting, actuary, outside experts, and they have to follow these particular, and these smaller bullets come right out of that FAR cost principle. And then you're going to have to demonstrate that you tried to negotiate a settlement, and that's with emails, other records and timesheets, what management people were involved in these things, because that's a recoverable cost. Lawyers and their timesheets, accountants and their timesheets are going to be recoverable costs. And you had XY meetings and presumably multiple meetings, multiple conversations, and you've got a record of all that. And you put that in with your request for equitable adjustment as a contract administration cost. And that's it. Finished with it. I think I just barely made the deadline. And if you have any questions, you'll see my contact information at the end. And just send me an email, and I'll see if I can address a question with you, or excuse me, for you as easy as possible. Okay. So I'm done, Mallory, if you're good.
Okay, yeah, thank you, David. That was a lot of great information. Thank you for everybody who joined us. If you have any questions for David, like you said, please contact him directly with the contact information you see on your screen. At 12:30, we are covering keeping your books clear of federal unallowable costs. So join us then. Thank you, everybody.
Yeah, take care.